India's commitment to international humanitarian law is not merely a legal obligation but a reflection of its historical ethos, where righteousness in warfare, human dignity, and justice remain paramount even in the face of conflict. Humanitarian law serves as the cornerstone of ethical conduct in armed conflicts, ensuring that even in the times of war, fundamental principles of humanity are preserved. Rooted in the idea that war must not be waged without constraints, international humanitarian law seeks to minimize suffering by establishing clear legal boundaries for combatants and protecting those who are not actively involved in the hostilities. Unlike other legal framework that governs the peacetime activities, international humanitarian law is specifically designed to address the realities of warfare, ensuring that humanitarian principles remain intact even amid violence and destruction. At its core, international humanitarian law rests on the principle of distinction, proportionality, and necessity. The principle of distinction mandates that warring parties differentiate between the combatants and civilians, ensuring that non-combatants are spared from direct attacks. Proportionality restricts the use of excessive force, emphasizing that military operations should not inflict harm disproportionate to the anticipated military advantage. Necessity, meanwhile, dictates that any act of war must be justified by clear military objective, preventing arbitrary or excessive destruction. These principles collectively form the backbone of international humanitarian law, guiding states and armed forces in their conduct during hostilities. The origin of humanitarian law can be traced to the tradition and moral codes, many of which emphasize restraint in warfare. From early civilization to religious doctrines, various societies have recognized that the need to mitigate the human cost of war. However, it was only in the 19th and 20th centuries that these moral imperatives were codified into binding international treaties, leading to the formation of modern international humanitarian law. The Geneva Convention of 1949 and their additional protocols remain the most comprehensive legal instruments governing the conduct of war, providing a universal framework for the protection of civilians, prisoners of war, and the wounded. The significance of international humanitarian law has grown in the contemporary world, where the armed conflicts often involve non-state actors, asymmetric warfare, and technological advancements such as cyber warfare and autonomous weapons. As warfare evolves, so too must often the application and interpretation of international humanitarian law to ensure its continued relevance. Countries across the globe, including India, recognize the necessity of adapting humanitarian law to meet the emerging challenges while upholding the fundamental objective of protecting human dignity in all circumstances. International humanitarian law, often referred to as the law of war and the law of armed conflict, is essential in regulating warfare and reducing its impact on both combatants and non-combatants. The core objective of international humanitarian law is to uphold the human dignity, ensuring humane treatment for individuals affected by armed conflicts, including civilians, prisoners of war, and the wounded. The principles of IHL are enshrined in the international treaties such as Geneva Convention and additional protocols, as well as in the customary international law. India's stance on IHL reflects a careful balance between its humanitarian commitments and concerns regarding sovereignty, national security, and internal stability. India's approach to IHL is profoundly influenced by its historical traditions and ethical philosophies. Ancient Indian scriptures, including the Mahabharata and Manusmriti, have long emphasized moral conduct in warfare. The Mahabharata, especially discussed in the discourse between Lord Krishna and Arjuna in the Bhagavad Gita, underscores the concept of dharma, yuddha, the meaning of just war or righteous warfare, which stresses the adherence to the ethical principles even during the battle. The Manusmriti outlines the rules for protecting the non-combatants, ensuring the humane treatment of captives, and minimizing unnecessary destruction. These tradition values resonate with the core tenets of modern humanitarian law, demonstrating that India's commitment to ethical warfare is deeply rooted in its civilization rather than being a recent development. India has ratified the four Geneva Conventions of 1949, which form the foundation of contemporary international humanitarian law, thereby reinforcing its dedication to protecting human rights during the armed conflict. However, it has not ratified the additional protocols of 1977, which extend the protections for combatants and civilians in both international as well as non-international armed conflict. India's reluctance to adopt these protocols arises from the concern that certain provisions might infringe upon its sovereignty or interfere with the internal security operations, particularly in the regions affected by insurgency and terrorism. Nevertheless, India remains committed to upholding the humanitarian principles and integrate them into its legal and military framework. India's domestic legal system incorporates several international humanitarian law principles to ensure their enforcement at national level. The Geneva Conventions Act of 1960 enables Indian court to prosecute individuals responsible for serious violations of Geneva Conventions, such as targeting civilians or engaging the acts of torture. Additionally, legal provisions within the Indian Penal Code, now BNS, criminalize war crimes, while the Army Act regulates the conduct of military personnel and prescribes the penalty for the breaches of wartime ethics. The Armed Forces Special Powers Act AFPSA, though widely debated, has been defended by the government as a necessary tool for maintaining security in the conflict-prone regions. Critics argue that this law may contradict humanitarian principles, while authorities maintain that it operates within a legal framework designed to balance the security needs with human rights consideration. The Indian judiciary has played a crucial role in interpreting and applying humanitarian law principles in domestic cases. Courts have consistently emphasized humane treatment even in conflict situations. Landmark judgments such as People's Union of Civil Liberties versus Union of India and Naga's People Movement of Human Rights versus Human of India highlight the judiciary's commitment of upholding the constitutional rights and preventing excesses in counter-insurgency operations. The Supreme Court reliance on Article 21 of the Indian Constitution, which guarantees the right to life and personal liberty, underscores the principle that fundamental rights must be safeguarded even during the times of conflict. India has also actively contributed to global humanitarian efforts through its participation in United Nations peacekeeping missions. As one of the leading contributors to the United Nations peacekeeping forces, India has constantly demonstrated its commitment to international humanitarian standards. Indian peacekeepers undergo extensive training in international humanitarian law and play a crucial role in protecting civilians and maintaining stability in conflict zones worldwide. Furthermore, India has been a strong advocate for fair and universal application of humanitarian law, emphasizing that all parties involved in the armed conflict, whether state or non-state actors, must adhere to international humanitarian law. However, India remains cautious about the legal framework that could be misused to legitimize the armed insurgencies or interfere in its domestic security policies. Despite its adherence to the core IHL principles, India has faced scrutiny from international organizations and human rights groups regarding the handling of conflict situations in regions such as Jammu and Kashmir and the northeastern states. Allegation of excessive force and human rights violation have led to calls for increased oversight and accountability. However, the government maintains that the security operations are conducted within the legal and humanitarian constraints, emphasizing the distinction between necessary counterterrorism measures and potential violations of human rights. This ongoing debate incites or highlights the practical challenges of implementing international humanitarian norms in complex security environments. The evolution of modern warfare, particularly with the advent of artificial intelligence, cyber warfare, and autonomous weaponry cases of additional challenges for international humanitarian law compliance. India recognizes the need for international discussions on regulating emerging military technologies for preventing unintended humanitarian consequences. As a country with growing technical or technological capabilities, India is expected to play a key role in shaping a global legal framework that addresses the use of advanced weaponry in armed conflicts. Addressing these challenges requires cooperative efforts to the international level to establish new guidelines that ensure the continued relevance and effectiveness of humanitarian law in modern warfare. India has made a significant effort to promote awareness and education on international humanitarian law, integrating humanitarian law training into military programs and legal studies. Disseminating knowledge about the international humanitarian law among security forces, legal professionals, and policymakers is crucial for ensuring adherence to humanitarian norms. Additionally, academic institutions, civil society organizations, and media plays a pivotal role in educating the people and public and advocating for stronger implementation of international humanitarian law principles. Increasing awareness and training can help foster a culture of respect for human rights and humanitarian values, strengthening India's overall commitment to humanitarian law. The relationship between IHL and human rights law further underscores the importance of protecting individuals in conflict situations. While international humanitarian law specifically governs wartime conduct, human rights law applied universally covering both peacetime and conflict situations. The contemporary nature of these legal framework highlights the need for holistic approach, safeguarding human dignity under all circumstances. India's adherence to both IHL and human rights law reflects its broader version of justice, peace, and equity at both national as well as global level. As an essential component of international legal framework, international humanitarian law plays a critical role in regulating armed conflicts and ensuring the protection of those affected by war. India's perspective on international humanitarian law is shaped by its historical values, constitutional principles, and strategic consideration. While strongly committed to the financial and fundamental tenets of IHL, India adopts a pragmatic approach, balancing its humanitarian responsibilities with national security concerns. By engaging in global humanitarian initiatives, strengthening domestic legal structures, and addressing new challenges in warfare, India has continued to uphold the ideals of humanitarian law, while aligning them with its long-term vision of just and stable world. Those sustained efforts, policy refinements, and constructive international engagements, India reaffirms its dedication to the protection of human rights in conflict situations, reinforcing its position as a responsible global actor committed to humanitarian values.